Traditional professional liability policies weren't written for algorithmic errors. Today, I'm examining a critical question every firm using AI needs to answer. Does your E&O insurance actually cover mistakes made by artificial intelligence? Here's the fundamental problem. Errors and omissions insurance has long existed to protect professionals from human misjudgment, the missed clause, the wrong forecast, bad call. But now that artificial intelligence writes memos, performs due diligence, reviews discovery files, the question is becoming urgent. Does E&O insurance still cover the mistakes when the professional is partly a machine? According to a recent analysis by the American Bar Association Journal, the answer is often no, or at least it depends. What counts as an AI mistake? Well, AI errors defy tidy categorization. They can hallucinate citations, generate biased language, misclassify data based on skewed training sets. The distinction between tool malfunction and user negligence is blurred. Did the human rely too heavily on the model, or did the algorithm malfunction? Insurers care about that line because coverage often turns on whether the act was a professional service or a mechanical failure. The NST AI risk management framework identifies several categories of AI risk, from training data bias to lack of transparency. However, these AI risk categories do not map neatly onto traditional insurance policy concepts, which can create coverage disputes. Inside the typical E&O policy, most professional liability policies hinge on several core phrases: wrongful act, professional service and damages, non-anticipated probabilistic models. A lawyer who files an erroneous motion or an accountant who miscalculates a balance sheet fits the traditional mold. But when a model trained on large data sets suggests a course of action, it's unclear whether that suggestion counts as professional advice or mere software output. Technology, E&O, and media liability hybrids offer broader coverage, but many policies exclude data processing or software defects. That gap leaves a gray zone where algorithmic misfires may fall between product liability and professional negligence. Insurance Journal noted in November 2024 Viewpoint that professional liability policies typically provide coverage for claims arising from professional services, but whether AI-assisted work qualifies remains unresolved in many policy forms, with coverage often depending on specific wording and available endorsements. This is where AI slips through the crack. Traditional E&O coverage often excludes losses arising from mechanical or electronic errors or software malfunction. Those carve-outs were designed for broken hardware, not self-learning systems. When a generative model creates a defamatory passage or outputs fabricated facts, the insurer may argue that no professional judgment occurred, only a data processing event. That distinction can mean the difference between a covered loss and a costly denial. Even intent-based exclusions raise new problems. If an algorithm learns to produce discriminatory results, does that qualify as intentional bias? The answer is unsettled. The Harvard Law School Forum on Corporate Governance warns that E&O policies may not respond as expected when AI contributes to a negligent outcome, particularly where the insured cannot show documented human oversight and review of AI-assisted work. When cyber insurance enters the picture, the boundary between E&O and cyber insurance becomes murky when AI is involved. If an AI system is hacked and produces erroneous outputs, is that a professional error or a cybersecurity incident? If an AI tool mishandles personally identifiable information and triggers a data breach notification, which policy responds? Most cyber policies cover data breaches and privacy violations, but they typically exclude professional services. Conversely, E&O policies cover negligent advice but exclude cyber events. When AI sits at the intersection providing professional services while processing data, firms can face disputes over which policy responds, with each carrier scrutinizing whether the matter sounds or falls in cyber or professional services. Marsh notes that generative AI impacts multiple lines of insurance, including technology, E&O, cyber, professional liability, and media liability, creating potential coverage disputes over which policy responds. Consider an AI-powered contract review tool that inadvertently exposes confidential client information to other users due to a prompt injection attack. Is this a data breach under cyber coverage, professional negligence and tool selection under E&O, or both? The answer may depend on policy wording, the sequence of events, and which insurer has better coverage. Insurers are beginning to adapt. Some carriers have added explicit AI exclusions, citing the unpredictable nature of generative systems. Others are piloting affirmative endorsements that carve back limited coverage for algorithmic errors. For example, Munich Re has introduced AI Sure, a product that aims to backstop AI model performance in defined settings. Brokers such as Marsh and Aon report growing interest in bespoke policies covering AI model governance, data bias, and training set integrity. Aon's 2025 risk capital trends analysis identified AI cyber threats as one of the key challenges organizations face, noting that the interconnected nature of AI risks require new insurance policies, but these policies remain niche and are priced cautiously, often with sublimits and tighter reporting obligations than traditional E&O coverage. Coverage scenarios where the disputes may arise. While courts have yet to rule definitively on E&O coverage for AI-related errors, coverage attorneys and insurance brokers warn that traditional policy language creates significant uncertainty. Here, let's examine several realistic scenarios where coverage disputes could arise. First, law firm scenario. An associate uses an AI brief generator that fabricates citations. The client is sanctioned, sues the firm for malpractice, and the insured denies coverage, arguing failure to supervise a software tool does not constitute a covered professional service. Marketing agency scenario. Generative model posts promotional text containing a false medical claim. The insurer disputes whether the act involved editorial control, which would be covered, or constituted an autonomous system failure, which would be excluded. Now, healthcare technology scenario. A predictive diagnostic tool misclassifies patient data, leading to delayed treatment and adverse outcomes. Coverage may depend on whether the insured was the software's developer, triggering product liability, or its user, triggering professional liability. Financial services scenario. This is the last one. An AI-powered loan underwriting system systematically denies applications from protected classes due to biased training data. The resulting discrimination lawsuit triggers both regulatory fines and civil liability, but the E&O carrier argues this loss stems from system design rather than professional judgment. Jurisdictional differences. In the United States, bar associations and insurance industry groups are still debating how to classify algorithmic errors. Canada's financial and professional regulators have issued advisories, but no formal guidance on binding on insurance. Meanwhile, intellectual property disputes are creating another layer of insurance complexity. The New York Times lawsuit against OpenAI and Microsoft, filed in December 2023 and currently proceeding in federal court, and similar copyright claims raise questions about whether E&O policies cover infringement allegations stemming from AI training data or outputs. Most E&O policies exclude intellectual property violations or limit coverage for advertising injury, leaving professional firms that use generative AI exposed to uncovered copyright claims. For now, courts have yet to decide a definitive test case directly linking E&O coverage to an AI-generated mistake, though several disputes are reportedly in early litigation or settlement negotiations. What about directors and officers' liability? Beyond E&O exposure, corporate boards face potential directors and officers' liability for inadequate AI governance. Shareholders and regulators are beginning to scrutinize whether boards exercise adequate oversight when authorizing AI deployment in high-stakes environments. Legal and insurance professionals anticipate that derivative lawsuits alleging failure to implement AI risk controls could emerge, particularly after public AI failures that harm company reputation or trigger regulatory action. Disclosure risk is also rising. In March 2024, the SEC brought enforcement actions against two advisors for alleged AI washing in marketing materials, a reminder that misstatements about AI capabilities can create securities exposure. What law firms and businesses should do now: they should review policy definitions carefully, especially professional service, data processing, and technology wrongful act. Request specimen policy language from your broker before renewal and compare definitions across carriers. Pay particular attention to exclusion for mechanical errors, software defects, and intellectual property violations. Underwriters are treating AI the way they once treated cloud computing, first with caution, then with custom endorsements, and eventually as standard risk class. The next generation of E&O forms will likely reference AI-assisted professional services explicitly with defined terms for algorithmic outputs, training data quality, and human supervision requirements. Until then, Professionals who rely on AI must assume that their coverage depends on a human signature and that algorithms still live outside the legal definition of judgment. As one insurance expert observed, if you can't demonstrate where the human exercised discretion, it becomes difficult to show where the policy responds. The best protection against AI-related mistakes starts long before the insurer ever gets involved. Firms need systems and workflows that catch AI errors before they reach a client or court. Human verification must be built into every step. The more human oversight you can show, the stronger your argument that any mistake was professional judgment, not a machine malfunction. This issue goes far beyond fake case citations. Imagine a lawyer relying on an AI-generated argument without checking its legal footing or trusting an AI summary of medical records that overlooks a crucial nurse's note. Those are failures of supervision, not technology. Verification is what turns AI from a liability into an asset. The deeper problem is that insurers still don't have enough data to model the AI risk. They don't yet know how to price it or what coverage should look like. That will change as more claims emerge. For now, every firm should talk directly with its insurer to confirm how their current use of AI fits or doesn't within existing coverage. This uncertainty makes documentation critical. Use AI platforms that log every prompt and output and establish firm-wide safety protocols that show how AI work is reviewed. Those records may one day prove just as valuable as any insurance endorsement. Thanks for watching.